A judge walked into a dry cleaner on a Tuesday in May. The dry cleaner lost his pants. So the judge sued them for $67 million. 700 years of that family's dry cleaning income for a pair of suit trousers worth, at most, a few $100s. And the man who filed that lawsuit had taken an oath to uphold the law. Here's the part that almost every headline got completely wrong. The pants were probably never lost at all. Roy L. Pearson Jr. was a newly appointed administrative law judge in Washington, D.C. That's a government-appointed official whose entire job is to impartially resolve disputes between private citizens and the state. He brought a pair of suit trousers to Custom Cleaners, a small dry cleaning shop on Bladensburg Road, operated by the Chun family. Jin, Sue, and their son Ki. South Korean immigrants who had built the business over years to establish a stable foothold in their adopted country. The trousers needed the waist let out. The alteration cost $10.50. When Pearson returned to collect them, the Chun said they had been sent to another branch temporarily. Then they couldn't find them. Then Sue Chun presented him with a pair of cuffed, charcoal gray trousers and said, "These are yours." Pearson said they weren't. That disagreement over a $10.50 alteration became the most covered consumer lawsuit of the decade. The question was never really about the pants. To understand what Pearson did next, you need to understand who he was in May 2005. He had just won his judicial appointment the previous month. He had come through a financially draining divorce. And he had recently gained weight, which is why he was bringing his suit trousers in one by one to have the waists altered. He needed them to look the part in court. On May 3rd, he dropped off two pairs, a burgundy and blue pinstriped Hickey Freeman suit he had bought from Saks Fifth Avenue, and an unrelated pair of charcoal gray trousers. Hickey Freeman is a brand worn by senators and managing partners at white shoe law firms. A single suit runs between $1,350. These were not casual pants. He returned on May 5th. Not ready. So Chun told him they had been sent to another facility. He came back May 6th. Still not ready. He demanded $1,000, the full replacement value of the Hickey Freeman suit. Then, on May 7th, Soo Chun presented a pair of cuffed charcoal gray trousers and said, "These are the ones you left with us." Pearson looked at them, rejected them on the spot. He said they were not his. On May 14th, he brought in the matching suit jacket so they could compare. Soo Chun pointed to the cuffed trousers again. Same style, same cuffs, consistent with the drop-off tags. Pearson refused. He walked out and decided the Chuns were committing fraud. That was the last time Roy Pearson patronized Custom Cleaners as a customer. The next time he walked through that door, he was a plaintiff. Pearson filed his verified complaint, the formal legal document that initiates a lawsuit, on June 7th, 2005. And here is where the story stops being about lost pants and starts being about something considerably stranger. The dry cleaner had 3 signs in its window. One said same-day service. One said all work done on premises. One said satisfaction guaranteed. Pearson, a licensed attorney, looked at those signs and saw not a marketing promise, but a legal liability engine. He argued that the Consumer Protection Procedures Act, DC's statute giving private citizens the right to sue businesses for deceptive trade practices, had been violated. Not once, but every single day those signs remained in the window. Under his reading of the law, each day a deceptive sign was displayed was a separate statutory violation. The act allowed $1,500 per violation per defendant. The Chums had 3 defendants on the suit. 3 signs, hundreds of days. You can already see where this is going. What Pearson built next was not a lawsuit. It was a mathematical formula for financial destruction. Pearson's interpretation of satisfaction guaranteed is worth its own paragraph because it is genuinely unlike any legal argument that had been made in a D.C. courtroom before. He argued the sign was not a marketing commitment. It was an unconditional, legally binding warranty of satisfaction, as defined entirely by the customer, with zero requirement of reasonableness. Under his reading, if a customer demanded $1 trillion and the business refused to pay it, the business was in breach of the guarantee and liable under the statute. He wasn't using hyperbole. He made this argument in court filings with a straight face. He cited federal advertising regulations to support it, specifically a section governing deceptive guarantees. He simply omitted the subsection directly above it, which restricted the remedy for an unqualified guarantee to a full refund of the purchase price. Not an unlimited check, a refund. The same-day service sign received the same treatment. His argument, regardless of when you dropped off your garments, regardless of volume or complexity, the sign unconditionally promised same-day completion. The presiding judge later wrote that this interpretation frankly defies logic, a sentence that in judicial opinions functions as the legal equivalent of a tired sigh. A judge in Washington, D.C., surrounded daily by the machinery of American governance, had to put in writing that a dry cleaner is not obligated to press your trousers in the 12 minutes between your arrival and closing time. By November 2005, the claim had grown from $1,000 to $285,000. By September 2006, it had crossed $10 million. By May 2007, the eve of trial, it stood at $67,292,500. The breakdown: $3 million for emotional distress, $500,000 in attorney's fees for himself, since he was representing himself, $90,000 for a 10-year rental car lease because he claimed the missing pants forced him to take a different bus to work, and $51.5 million to be placed into a fund for dissatisfied DC consumers. The Chuns had two choices: settle or fight a lawsuit compounding by the hundreds of thousands every few months. They chose to fight. It nearly destroyed them. The Chun family had no business insurance that covered litigation of this scale. They closed 2 of their 3 dry cleaning shops to redirect funds toward their legal defense. The Bladensburg Road location, the one where all of this had started, permanently closed in September 2007. Their legal bills exceeded $100,000. That is roughly the equivalent of 2 full years of household income at DC's median at the time, for a lawsuit about trousers. Their attorney, Christopher Manning, went to work with what evidence he had: the tags, the belt inserts, the drop-off receipts. Sue Chun testified that the cuffed gray trousers she had presented to Pearson carried unique identifying marks consistent with the tickets he had received at drop-off. Pearson, representing himself, had to conduct his own direct examination from the witness stand. He sat in the witness box. He asked himself questions. Then he answered them. While describing the emotional devastation caused by his missing trousers, he broke down and wept. The trial recessed so he could collect himself. When proceedings resumed, there was still one thing Pearson had not resolved: the fact that no one had actually proven the pants were gone. This is the detail that gets lost in every headline about this case. Judge Judith Bortnoff's final opinion addresses the pants question directly. Pearson needed to prove by clear and convincing evidence. That's a legal standard requiring something substantially stronger than a guess or a hunch, closer to near certainty, that the cuffed gray trousers Chun presented were not his. He did not meet that standard. His own witnesses testified largely to general customer service frustrations at the shop. One compared the Chun's business practices to those of the Nazis. The comparison drew immediate objections and illuminated something important. The atmosphere around this lawsuit had nothing to do with consumer protection anymore. The Consumer Protection Procedures Act Pearson was using was written to protect ordinary people from corporations running systematic deception schemes, payday lenders, bait-and-switch advertisers, companies that sold things that didn't exist. Roy Pearson used it to demand $67 million from a South Korean immigrant family over a disagreement about which pair of gray trousers belonged to him. On June 25, 2007, Judge Bartnoff issued her ruling. She ruled for the Chuns on every single count. Every one. The payants had not been proven lost. The satisfaction guaranteed sign was not an unconditional promise. It was subject to a reasonable consumer standard. What would a rational person expect when they see that phrase in a window? No rational person, the court found, would interpret it as a guaranteed right to unlimited compensation for any claim, however unreasonable, however made in bad faith. Same-day service applied when same-day service was requested and feasible, not for every garment dropped off at any hour. Pearson received nothing. He appealed. A three-judge panel at the D.C. Court of Appeals heard the case in December 2008. They unanimously affirmed the lower court. He petitioned the full 9-judge court to rehear it. They declined, unanimously. His only remaining option was the Supreme Court of the United States. He didn't file. The $67 million was built by compounding statutory violations daily across 3 defendants, 3 signs, hundreds of days, using a theory the appellate court described as having no support in law or reason. The payants, in all likelihood, were his all along. But the case didn't end with Pearson losing the lawsuit. In May 2007, while the trial was still pending, the D.C. Commission on Selection and Tenure of Administrative Law Judges voted not to reappoint him to a full 10-year term. The reason cited in their decision? Lack of judicial temperament. He lost his job while his own case was still in court. He then sued the District of Columbia government for $1 million, claiming his removal was unlawful retaliation for protected speech. He lost. In 2020, 15 years after a pair of suit trousers, the D.C. Court of Appeals suspended his law license for 90 active days. Here is what this case actually settled, and why it matters to anyone who has ever signed a contract with a satisfaction guaranteed clause, or seen one on a receipt, a product box, or a window. The court established a clear legal standard. Satisfaction guaranteed is a promise to make reasonable efforts to remedy a legitimate problem, judged by what a reasonable consumer would expect, not what an unreasonable one demands. That standard now governs how consumer protection statutes apply to merchant guarantees in D.C. It has been cited extensively in consumer law scholarship across the country. The case also forced a serious conversation about the architecture of consumer protection law. Statutes like the CPPA and similar laws in most U.S. states do not require you to prove actual financial harm to file a lawsuit. They allow statutory damages per violation. They empower private citizens to enforce consumer rights. That is intentional. These laws were designed to give ordinary people leverage against large corporations that could absorb individual lawsuits without changing their behavior. What Pearson versus Chun demonstrated is that the same mechanisms, applied without any screening for plausibility, can obliterate precisely the kind of small businesses those laws were built to protect. If you have ever seen satisfaction guaranteed anywhere, you now know exactly what it can and cannot legally mean for either side. I want to know how you'd have ruled. If you had been the judge in that courtroom, would you have found any part of Pearson's argument worth taking seriously? Leave your verdict in the comments. I read every one. If you're not subscribed yet, that button exists. Next week, the non-disclosure agreement that accidentally made public everything it was written to hide, including the name of the person it was designed to protect. The company that drafted it had no legal recourse whatsoever.